Hello, everybody, and thank you for attending today's session. We appreciate your time and commitment to this important topic. I'd personally like to say I'm sorry for the slight delay, as you possibly expect, like anybody who's trying to do a presentation on webinar. We've had a few technical hitches, but hopefully everything's back on track now. So really good to see so many people attending this event. So I'd just like to move forward by saying we know how much there is for nursery owners and managers to keep on top of employment law changes, and it can often feel very complex when you're trying to understand what they mean in practice for you and your teams and the settings that you operate within. Having had my own business, I'm really grateful to Stephensons for helping us guide our business through this sort of various challenges that are taking place. So without further ado, I'd like to introduce Phil Richardson, partner and head of employment law at Stephensons, who is also joined by Adam Pennington and Stephen Woodhouse, both partners in the employment law team. They'll be leading today's content and answering questions during the panel's Q&A at the end. Before we start, just a quick note that cameras and microphones will remain off throughout this so that we don't get any interruptions, and the session is being recorded. Please do make use of the Q&A functions as questions come to mind. We'll be building those up in the background and bringing them in at the end of the session. So over to you, Adam.
Thanks, Jackie. Thanks for that. Good afternoon, everyone, and thank you for joining us this afternoon. So myself, Steve and Phil will be talking with you this afternoon about some of the changes which have come in via the new legislation, some of which has already been implemented in April. I'll take you through those changes. Stephen will be talking through some of the changes that are coming through in October, and Phil's looking further ahead to next year. Let's just see if hopefully I can take control of those slides. Right. Does that work? Can everyone see? Does that work through on the next slide, Amy? I think, can everyone see that?
You want introduction? Yeah, everyone can see that.
That's perfect. Great. I just want to check I've got control there. Right. So as I say, some of those changes have already taken place in April, but I'm going to go back over those just to remind us of what we should have in place before handing over to Stephen. So trade union activity, I won't spend too much time on those changes. What I've done is highlight those of particular significance. And these are changes which took effect in February 2026. So first up, we have dismissal for taking part in industrial action is now automatically unfair. However, the Employment Rights Act 25, this removes the requirement for that dismissal to take place during the first 12 weeks of industrial action, which is also known as the relevant period. So in other words, employees will be protected from unfair dismissal during any lawful industrial action that occurs within the lifetime of the mandate of the ballot for industrial action. Secondly, the time needed to give notice of industrial action has been reduced to 10 days. That was previously 14 days. Thirdly, industrial action.
Sorry, Adam. We're just picking up on the chat. There's a few people who are commenting that they can't see the slides. I'm just conscious. Is there anything, Amy, we could do about that? I think everyone, I think it's 4 or 5 people said they can't see it. I'm just wondering if we can help resolve that.
Yeah, let me have a look.
Thanks, Steve.
Is that in here? No, this is the portfolio. I know what you mean.
Is that improved? Can people see the slides now?
If you can just comment in the chat just to confirm you can. Certainly I can now. Sharon says she can, so that's great. Thanks, Sharon.
Yes, we got that.
Other Sharon does as well. Okay, so we seem to be working that way. We are. Thanks everyone for sticking with us. We are having technical issues. It may be easier if we continue with this pattern rather than trying to take control. If that's okay, Amy.
Yeah. So
Thank you.
Phil's
Sorry,
going to
Adam.
be driving the slides. Phil, you're in control of the slides, just to confirm.
Right, okay. So if I just navigate back to the introduction,
We're okay on that page there, Phil.
we're okay.
Yeah,
So
that's great.
everybody, yeah, hopefully can see those slides now. And I'll just, Adam and Steve, you just let me know when you're finished on that slide, and I'll just flip them over.
That's great.
Flip them over to the next
Thank you.
slide. Thanks.
Thanks. So just a quick recap here, quite quickly through the trade union activity. Dismissal is now automatically unfair. Hopefully you can see that up on the slide now, reducing the notice to 10 days instead of 14. Thirdly, industrial action mandates for ballots which are opening on or after the 18th of February 26. Those are extended to 12 months. That was previously 6 months. And finally, the support threshold rule has been removed. So that was a rule that required at least 40% of the total eligible votes to support action. It applied to really important public services. Public and private sector ballots now follow the same requirement. They only need more votes in favour of industrial action than against it. So just some practical considerations. I'm not sure how many of you recognise a union, but things that we've considered: tighter contingency planning. So the shorter 10-day notice period means that you guys as employers have less time to prepare for essentially what may be disruption. So contingency plans must be reviewed to ensure they are actionable within that shorter window. There's longer term risks. So with a 12-month mandate, unions can call action months after a ballot, requiring employers to maintain consistent risk assessment rather than treating strike threats as short-term issues. Think about dismissals. So the removal of the 12-week limit for protection against dismissal means that dismissing anyone for taking part in industrial action is extremely high risk. We must ensure that, therefore, we have robust, non-strike related reasons for any dismissal, or of course wait until the dispute is resolved. If we could move on to the next slide, please, Phil. Is everyone able to see that? I just want to check that we should be on paternity leave and ordinary parental leave. If you can let me know if you can see that.
That's working for us, Adam. I think we're getting some thumbs up.
Perfect.
Anybody else having issues, just let us know in the chat. Thank you.
That's great. So again, this is coming in the last couple of months with effect from the 6th of April this year. Following important changes have come into effect. So currently someone must have worked for their employer for 26 weeks. However, from the 6th of April, paternity leave will become a day one right, which essentially allows someone to give notice of leave from their first day of employment. Ordinary parental leave or unpaid parental leave, that will also become a day one right. Previously, someone who'd worked for their employer for a year or had to work there for a year to be eligible, but that is now a day one right. Under those previous rules, paternity leave and shared parental leave were mutually exclusive. However, these changes in April remove that restriction. And so from April 2026, eligible fathers and partners will be able to take paternity leave even if they've already taken shared parental leave. It's important to note, however, that the 26-week qualifying period for statutory paternity pay, that remains unchanged. Eligible fathers and partners will be able to take up to 52 weeks of unpaid bereaved parents' paternity leave if the mother or primary adopter dies They must take that leave within 52 weeks of the child's birth, which includes surrogacy, adoption placement, or entry into Great Britain if it's an overseas adoption. Again, this is a day one right with no minimum qualifying period, and is specifically intended to support, of course, the surviving partners with caring responsibilities during a period of essentially significant trauma. The bereaved partner's parental leave, just to be clear, that's separate legislation, but something that we just wanted to draw to your attention, just to ensure that you're aware of these changes. And so some practical considerations for you guys. First one, of course, if you've not already done so, important to update your policies and staff books. Review and update the paternity leave policy, of course, parental leave policy, shared parental leave, and the bereavement and compassionate leave policies if you have those. Make sure that they now reflect the new day one rights and the removal of those restrictions. These should have been updated before April 2026. And of course, don't forget to go and check and update any intranet pages, onboarding materials that you may have issued, and any other employee guides that you have. Consider reviewing recruitment and onboarding materials. So because these entitlements start from day one, we've got to bear in mind that candidates and new starters may be asking questions about them. So make sure that managers, those involved in recruitment and onboarding, understand these changes that have come in particular, the new eligibility rules, how notice for paternity leave can now be given from day one, and also your internal processes for managing those requests. It's important to prepare and train managers and those in HR. Of course, line managers will often be the first point of contact, so they need clear guidance. Consider, if you haven't already done so, running short training sessions, updating frequently asked questions, and you may consider scenario-based guidance, especially for requests made early in employment. Workforce planning, so review your resourcing and cover arrangements and consider building in some flexibility to account for the possibility of more short notice leave requests. Of course, we need to make sure that payroll and HR systems are ready, and to check your HR and payroll systems to make sure that they recognize, again, this day one eligibility, entitlements are being flagged correctly, and we're able to generate compliant letters and documentation to staff who are affected. And if we can move on to the next page, Phil, the next slide, we should be coming on to sick pay. So hopefully that has brought up the sick pay slide. Yeah, we've got the thumbs going again. That's great. Okay, so previously, of course, SSP operated with a number of qualifying conditions. Employees had to earn at least £125 per week or the lower earnings limit to qualify for SSP, and payment would only begin from the 4th qualifying day of sickness absence, which left the first 3 days unpaid unless, of course, the company operated an enhanced sickness policy. First important thing to note is the removal of those waiting days. So this long-standing requirement for employees to wait 3 days before in SSP, that's gone from April 2026. And from that date, employees will receive SSP from their first qualifying day of sickness absence. The reason for this is the government believes that this change will support phased returns to work, as employees will be entitled to SSP for each day not worked due to sickness. And so, for example, a full-time employee returning to work on a 3-day per week basis following a lengthy absence will receive SSP for the remaining 2 days. We get rid of the lower earnings limit. So as I said earlier, the requirement to earn at or above £125 per week will be removed entirely, extending SSP eligibility to all employees regardless of their income. That change, it's hoped, will bring additional workers, including part-time staff, those on 0 hours contracts, and lower paid employees within the scope of statutory sick pay protection. There's a new payment calculation. So for lower earners, SSP will be calculated as 80% of normal weekly earnings, or the flat weekly rate, which is £123.25 from April, whichever is lower. So 80% of normal weekly earnings, or £123.25, whichever is lower. That's how SSP is now calculated. That 80% calculation is intended to strike an appropriate balance, if you like, between providing financial security to employees while limiting additional costs for businesses. So some practical considerations for you guys in light of these changes on sick pay. The government estimates that removing the waiting period and the lower earnings limit will cost employers approximately £450 million per annum, which equates to roughly £15 per employee. Those reforms are likely to have the greatest impact on companies who have large, low-paid workforces that don't currently offer contractual sick pay, and certainly those experiencing higher rates of short-term sickness absence. So one way in which to manage these changes is to consider the following. Of course, review and update sickness absence policies to remove reference to waiting days and the lower earnings limit. Any equivalent waiting period in company sick pay schemes should also be reviewed. We just need to check payroll systems are updated to accommodate the new 80% calculation for those lower earners and the removal of the 3-day waiting period. Important for companies to liaise with payroll providers to confirm when those system updates will be available. Carry out an absence audit covering the past, we would say 12 to 24 months, just to model the financial impact potentially of those changes, as we may need to start adjusting budgets accordingly. Managers again need to be trained on dealing with sickness absence effectively, maintaining accurate absence records, and identifying patterns that may warrant further investigation. Strengthen those return to work interviews and absence management procedures, and consider appropriate trigger points for formal discussions about attendance. And then just coming up on the next slide, we have changes to, hopefully we can see that slide, collective redundancy protection award. Now, previously, when an employer was proposing to make redundant 20 or more employees at one establishment within a period of 90 days or less, they had to consult with representatives of affected employees. That consultation had to begin in good time. And where the employer was proposing to dismiss 100 or more employees at one establishment within a 90-day period, at least 45 days consultation had to take place before the dismissal could take effect. If less than 90, if less than 100, at least 30 days. And that 45-30 timescale also applied to the company's duty to notify the Secretary of State of its redundancy plans. Some of you may have done this using Form HR1. Now, what the changes do, the legislation still retains the existing one establishment trigger, but also adds a second alternative trigger to cover cases where employees are being made redundant at more than one establishment. So just something to be aware of if you are operating from a number of sites and depending on how many employees you employ there, if redundancies are being considered. And that's important because in the event of non-compliance, currently a protective award may be ordered of up to 90 days gross pay for each affected employee. A failure to provide the HR1 form risks a criminal offence, but the Act doubles the maximum protective award from 90 days to 180 days. So that will be 180 days gross pay for each employee who is affected by that redundancy if there are any failures to consult with them. The government's intention is to introduce regulations setting out what the second trigger threshold is before some of those changes come into place. And so just some practical considerations for you as employers. Once we have this new threshold in force, it will particularly affect companies which, as I mentioned earlier, operate across more than one location. Those companies should implement centralised tracking of redundancy proposals to monitor whether the new threshold is being met. Audit the redundancy procedures, so review your collective consultation approach to ensure compliance, particularly when proposing 20 or more redundancies within 90 days. Extend the consultation timeline, so you may consider building in longer consultation periods, even beyond those statutory minimums, just to avoid any allegations of the company trying to rush the process or failing to genuinely consult with staff. Particularly because the cost of that failure has doubled from the 90 days to the 180 days. Prioritise genuine consultation, so focus on genuinely consulting on ways to avoid, reduce or mitigate the consequences of redundancy, rather than treating it as a procedural or tick box exercise. Documentation and training, of course, is important. Ensure we have meticulous documentation of the consult process and ensure that managers are trained, particularly in light of the increased risk and these specific legal requirements. We'll need to prepare for increased scrutiny. The government intends to produce a code of practice on collective redundancy obligations and to, as you may have seen, introduce a new Fair Work Agency, in which case we can expect closer scrutiny of redundancy decisions and consultation processes. Just moving on to the next slide then. This will be the final slide from me. Just a note on whistleblowing protection in the context of sexual harassment. So currently, as far as protected disclosures or whistleblowing concerns are concerned, employees must show that their concern fell into a category of wrongdoing, such as a criminal offence or a danger to health and safety, in order for their disclosure to be protected. And typically those were seen as relating to fraud or dangerous practices. But since 6th of April 26, now disclosures about sexual harassment will also be expressly recognised as a form of whistleblowing. Employees making allegations that sexual harassment has occurred or is likely to occur will be protected against being put to any detriment, which is any adverse treatment because of raising that concern. And they'll also be protected from unfair dismissal. And so even if they're employed for less than 2 years, their dismissal would be automatically unfair. And so the logic of this protection is to prevent employees essentially from feeling as though they can't speak up due to fear of career damage, being disbelieved or being labelled a troublemaker. So just considering some practical points for you guys in having to deal with this. First of all, of course, updating the whistleblowing policy to explicitly refer to sexual harassment as an example of reportable wrongdoing. We may wish to align sexual harassment, grievance and whistleblowing procedures to make the way that they will be triaged a bit clearer. Again, training managers and HR to recognise when a concern relating to sexual harassment may amount to a protected disclosure and how they should respond in a way that avoids allegations of detriment or victimisation. We may want to review non-disclosure agreements or settlement templates. And finally, strengthen your culture and reporting channels so that employees feel able to essentially speak up early on these important topics. So that's everything from me. I'll hopefully pass over to Stephen, who'll be talking about some of the changes coming up later this year.
That's great. If I can just say in the meanwhile, we've just had one question come in. So I think if we can answer maybe questions at the end, if that's possible, because we've certainly got one from Tiny's 3 Counties nurseries. So if that's okay before we move on. Okay.
No problem.
Okay, thanks, Michelle, and thanks, Adam. That was really useful there. Could everyone hear me first of all? Just a thumbs up if you can, just to let me know. We all got me. Yeah, there we go. That's good. Right. Okay. So we're going to turn on to my area of the discussion today, and what I'm going to be looking at is those changes which are coming in the autumn, in October 2026. The changes that Adam has discussed already have either come into force or are about to come into force imminently. They're locked in. But as we know with these things, there's lots of consultations going on. I read something this morning that the feedback from one of the government consultations was just published. So it's very much a movable feast, this, and there are definitely things to be ironed out for my changes, and certainly as Phil goes on to discuss his in 2027. So very much keep your ear to the ground. But all of these changes are going to be coming in, so we need to be arming ourselves with the knowledge now, so that we can consider how best to prepare ourselves for them. And the first major change I'm going to discuss there is listed on the slide, which is the changes to the prevention of sexual harassment in the workplace. Now, to look at this, we need to understand the present position and how things are then expected to change from it. And the present position is quite new as well. It was only introduced in October 2024. And the obligation on employers is to make sure that they're taking reasonable steps to prevent sexual harassment in the workplace. And the publicity around that, around the publication of that legislation was quite significant. And I think that has encouraged more claims of this nature to be brought before an employment tribunal. And in fact, we know that because it's borne out by these stats. There was a jump pre-introduction of that legislation from around 457 cases to 1,375 in the period in the equivalent period, that followed afterwards. So we know that when these things change in the legislation, it does result in further claims. So we've got to be ready and prepare ourselves, which I'll come on to discuss in a moment. So that was the October 2024 position. And of course, now I'm looking at October 2026. What's changing? Well, it changes from taking reasonable steps to taking all reasonable steps to prevent sexual harassment. And the introduction of that word all naturally is going to place a greater burden on you as employers, and it's going to raise those standards to a higher bar in terms of your role in that prevention. But I'm sure you're all sat there thinking, well, what does that mean? What does it mean for me and my business? How can I address that? Rather unhelpfully at the minute, we certainly don't have absolute clarity and direction from the government as to how we do that. You know, what are the rules and regulations around it? So we do, as employers, have to apply our minds to the issue carefully for the moment, but further guidance is expected. What we do know is that all reasonable steps does depend on a number of factors. The major ones being the size of your business, the resources, the working environment, and the identified risks that can arise. You know, are you in an organisation that's more likely to have incidents of sexual harassment, for example? All of those things will need to be taken into account in terms of what steps you need to take. So we'll look at that in a moment. I just want to touch upon the area of harassment just on the next slide, Phil, if you can. That there is an extension of harassment in a wider sense, and that concerns third-party harassment liability. And what this says is that employers can be liable for acts of harassment committed by third parties against their employees. So that could be a customer, a client, for example, anybody who's perhaps accessing the building. There might be somebody who's a contractor who's doing work. You have a duty to prevent harassment by any third parties. and make sure that you've got policies and procedures in place to that. But just coming back to the point about how we prevent harassment and sexual harassment, I think that the terms are interchangeable in terms of the steps we can take to do that. If we just go on to the next slide, Philip, we've got a list of things that we can do to prepare ourselves for that. And the first one there is to develop an effective anti-harassment policy. So we want a clear, regularly updated policy which addresses sexual harassment, outlines what's unacceptable and the types of behaviour we don't want to be seen and the types of behaviour we classify as harassment. And we need to provide clear reporting mechanisms. We need we need a place where the individual can turn to and a process for investigation in place, and also a method of supporting those victims as well. Okay. We also want to make sure that we are having engagement with the staff. So we want to be having regular one-to-ones, surveys, exit interviews, open door policies to identify issues and evaluate the effectiveness overall of our preventative measures on a regular basis. We need to be looking at risk assessments as well. What are the risks in our environment? Are there likely to be lots of third-party interactions or interactions which could prevent produce a risk of harassment incident occurring? We need to be making sure that we are doing what we can to look at the environment we're in and assessing that risk and recording that. So we've got a plan of action as to how we minimize it. We want to be encouraging reporting, as we've said. We want to be implementing effective reporting mechanisms that give us channels for raising complaints. So, for example, you might have, depending on the size of the business, you might have a designated person who is the go-to person who maybe HR or somebody at management level who is designated as your harassment or sexual harassment support person, and they have the confidence to go to that as perhaps they do the owner of the business as well. So think about who we can put in place as well as what we can put in place to mitigate the risks of any harassment. When something does happen, when there is a complaint of harassment that's made by an individual, that has to be taken at first at face value. It has to be taken seriously, and it has to be investigated and resolved appropriately. That doesn't mean that we have to discipline and find against the individual. We just need to be prompt and fair and even-handed with our investigation and make sure that we've got measures in place to prevent victimization of those people who come forward. They should be free to come forward without fear of reprisal for a genuine and honest complaint, even if there is no evidence that it actually occurred. But one key message I just want to leave you with on sexual harassment is that you are only required to do what is reasonable. So, okay, it is a heightening here from reasonable steps to all reasonable steps, but that word reasonable is really key. You cannot stop all incidents of harassment occurring. You can't be there in every room, in every part of the building at all times of the day. And you won't be penalised for not taking steps that are unworkable or impractical for you. It's got to be reasonable. It's got to work for you. That key term is reasonable. And that will also consider the size of the business, you know, how many employees you've got, but also the finances as well. Can you do all of these things? Do you have the financial capability and the funding, if you like, to put all of these steps in place? But those are some positive steps and ideas that you can reflect upon. And if you can't do something, be ready to explain why. So if there is a financial pressure that stops you having a particular system in place of reporting, then be ready to explain that should any issue happen. But the key thing is it's having reasonable steps in place. And as point 5 says there, we need to monitor and evaluate actions and procedures regularly. I'll come on now to the next slide to discuss the changes around trade union. Adam's discussion focused on existing trade unions. This section is more to do with new trade unions, new access to the workplace, and new obligations that we have to our employees. And the first one on the slide says that we've got an obligation to provide workers with a written statement of their right to join a trade union. Again, this is expected in 2020, October 2026, and we're expecting it's going to be provided alongside or as part of perhaps a contract of employment, or perhaps in a separate policy document. We are expecting further guidance again from the government, which hopefully will come very soon, because that change is coming in very swiftly indeed in the next 3 to 4 months. But we are expecting further guidance from the government on the exact content, the form, and the delivery method of that statement. But just to put it on your radar, that we will have an obligation to at least inform the individuals of their right to join a trade union. The second one, and perhaps the most controversial of these October trade union changes, is that the trade unions are going to have increased ability, let's say, to access workplaces. Now, under the current legislative framework, they don't have a general right to access workplaces, trade unions. They only tend to exercise their rights through individual members in the workplace or through access arrangements, which are already agreed with businesses on a voluntary basis. But the change in October is that if they're a qualifying trade union, they do have the right to access workplaces physically and by communication with workers on things like recruitment practices, organisational issues. But this does not include, in the first instance, industrial action. Okay. The government's communication on this, I think, and I may say this again, needs to be clearer. Okay, it needs to be improved. But I want to reassure you that it doesn't allow unions to simply walk into your workplace and unionize staff overnight. That's not the purpose of this legislation. And there is a code of practice, a draft code of practice that's in existence at the minute. It runs to 32 pages. I'm not going to, you'll be pleased to hear, run through that today. I'm just going to try and pick out some key points that I've taken from it. But despite these changes, the message from the government is clear. They want to be encouraging still voluntary access arrangements, or either existing or new ones. They want to keep it voluntary. This new process is more about when the voluntary system fails and you cannot get agreement between the employer and the union. So the code that's set down at the moment, and it is a draft code as far as I'm concerned, so it's still subject to amendments, but it does give us quite a tight window within which we've got to negotiate an access arrangement. So the first step is the union have got a right to us as employers. Then we've got to respond as employers within 15 working days. Okay. Now it is possible to agree a longer period by mutual agreement with the union, but that is a relatively short period of time. Once we respond, if the answer is yes, then obviously that's something which can be a voluntary arrangement between the parties. Where the problem's going to come is where you refuse the right of access for the union, and where that happens, you've got to justify that decision in writing. Okay. And it will ultimately go to what we call the Central Arbitration Committee, who will make a determination on whether or not that union should be granted access to the workplace if you're seeking to refuse and the parties can't reach an agreement. Okay, but the thing to know actually from the guidance is that the CAC, the Central Arbitration Committee, will have a presumption or an assumption in favour of some level of access unless there's a good reason for not doing so. So if an employer just simply says, I'm not letting them in, that won't wash with the CAC as far as the code tells us. But some good news on that, this doesn't apply to all organisations. So if a workplace has 20 or fewer than 21 workers, then this doesn't apply to them. So any business below 21 is excluded from these new rules, and the union need to make sure that they're doing everything they need to do. And if they fail in their procedural steps, again, this will not apply. There is a time limit also in any of these access agreements, so they can't be longer than 2 years. And I think, as far as I can read from the guide at the minute, that process will then start again, unless there can be an agreement. Okay. So there are checks and balances in place. So it is reasonable for you to refuse access if you're already recognised in a union who represents one or more of the workers who are subject to the application. And if access would require excessive resource allocation, or if the union are refusing to comply, with your policies and procedures, then that can be grounds where it can be reasonable for you to refuse. So I do appreciate it sounds daunting on the face of it, but to put your mind at rest, the mood music that we're hearing on the ground is that trade unions are going to be focusing their efforts, if you like, on much larger, well-known employers. Therefore, it's unlikely to impact a lot of small and medium-sized businesses, which is hopefully some comfort for some of you. Just some final points on trade union, the final 2 points on the slide there. There is an increased protection against detriment. I think Adam touched upon the right for individuals to participate in industrial action and not be dismissed from their job because they went on strike. The same goes for any detriment now. So it's expanding that right to those individuals. And a detriment is, using the plain understanding of the word, but typically in our context, it's subjecting somebody to a disciplinary process, cutting their hours, cutting their pay, giving them less favourable terms and conditions of employment. Those are examples of detriment that you are not allowed to do simply because the individual took part in industrial action. And as an extension of the access point, if access is granted, you've got to give appropriate facilities within your workplace and allow time off for union representatives to discharge their duties. I'll move on now to my final slide, which will concern the employment tribunal time limit. So at the moment, the position is that we have a 3-month time limit in the employment tribunal. And as noted on the slide there, from October, that will increase to 6 months in all claims, except for breach of contract for some reason, which will remain at 3 months. So unfair dismissal, discrimination, we're all expecting that time limit for individuals to bring a claim will be pushed from 3 months to 6. And that is, again, similar to the point I made about the access, on the face of it, fairly daunting, because it would seem to expand the scope of individuals who potentially make claims against the business, and it makes it really shines a light on the importance of early intervention of these things, because if we're not grasping the nettle, dealing with the issues head on within the workplace and completing our disciplinary investigations, etc., thoroughly, then we're going to be exposed to a greater risk of claims being brought because the time limit for them to bring the claims are being doubled. And it is a concern for me, I've got to say, in terms of the overall running of the employment tribunal system. The system, as some commentators have said, is already creaking at the seams. And bringing more claimants and claims into the system is just going to create a further backlog that's going to negatively impact on everyone, actually, if we look at it neutrally. All witnesses are going to struggle to remember things that happened 18 months, 2 years earlier. So it is important that if you do get notification of a tribunal claim, that you are safeguarding yourselves in terms of getting witnesses committed to assisting you at that trial. So, for example, if a discriminatory comment has been made by someone or alleged to have been made, you'll need that person perhaps to come to the tribunal as a witness. So it's important you lock those people in early so they're ready to support you with the ever-expanding claims that we're expecting to see in the coming years. That is everything from me, a whistle-stop tour of the October 2026 changes. I'm going to pass over to Phil now, who's going to take over to discuss further expansion of rights on unfair dismissal. Thank you.
Thanks, Stephen. Well, good afternoon, everyone. I'm just going to focus on the changes that are expected to come into place next year from 2027. So although they're a bit off, and as Stephen's touched upon, there's probably more meat to put on the bones with some of these changes. I think it is important to highlight what these changes are. Now, the most significant change, I would say, that is coming into force is opening up the right to bring a claim for unfair dismissal to more employees. And obviously, this is something you've got to be conscious of as employers. So currently, you're probably all aware that in order to bring a claim for unfair dismissal at the employment tribunal, an employee must have served 2 years service. And what this has meant is that if you have any concerns about a person's capability or conduct beyond the probationary period, it's generally, and I say generally speaking, being easier to let that person go without having followed sort of a full process as you do with employees of 2 years or more service. With effect from the 1st of January next year, all employees with 6 months or more service will be eligible to raise a claim for unfair dismissal. And that has retrospective effect. So any staff that you're recruiting, essentially with effect from tomorrow, when they get to the 1st of January, they will have built up 6 months service, meaning that they can bring claims for unfair dismissal at the employment tribunal. So what does that mean in a practical sense? Well, obviously, the natural consequence we anticipate is it will give obviously rights to many more of your employees eligible to bring this claim, and we expect it will increase the number of claims for unfair dismissal we see at employment tribunals. So now is really the time to focus on your contracts, review your handbooks and your policies and procedures, particularly in relation to grievances and disciplinary procedures, as you would expect. But also what we're advising you to all do, if you haven't done so already, is to look at your probationary period policy. So what we're advising employers is no longer to have a standard 6-month probationary period. The reason being is if that you were to keep that into place, the risk is that you would perhaps forget to address that person's performance until the 11th hour, and risk meaning that they would pass that 6-month threshold, meaning then you couldn't nip those issues in the bud and you would have to then follow a detailed capability process, for example. So what are we suggesting as an alternative? Well, what we're saying is to our clients is that they should have a standard probationary review at 3 months with the opportunity of extending that probationary period by a further 2 months. So essentially you've got a total period of 5 months in which to be able to make a decision about an employee's performance. What we would advise you all to do is to ensure you're regularly monitoring that and proactively monitoring that. What we're suggesting is monthly reviews, so it gives the employee opportunity to address any concerns about their performance and for you to feedback on performance too. And the idea behind that, of course, is you essentially want you've taken time to recruit these staff and you want to retain them. So if you're proactively managing any issues, hopefully those can be ironed out. But if not, obviously by the time you get to that 5-month period, you can make a decision to let them go and you can dismiss them on grounds of a failed probationary period without having to run the risk of an unfair dismissal claim following at that particular point. So just bear in mind those changes in relation to unfair dismissal. There's also going to be changes from January next year to the limits on compensation a person can claim at an employment tribunal if they're successful for unfair dismissal. Currently, there is a cap on how much you can claim, which, as it says on the slide here, is the lower of 52 weeks gross pay, or this sum of money here, £118,223, which, as you can all appreciate, is still a significant amount of money that you'd be looking at and exposed to if a claim was successful. But as of 1st of January next year, the government has sort of announced as part of these changes that there will be no limit and no cap on compensation. So theoretically, an employee can bring a claim at an employment tribunal as of next year, and there will be no ceiling and cap on unfair dismissal compensation. It will still be for a tribunal to decide what is just and equitable to award them, but nevertheless, that risk is there. So going back to the point in terms of what you could be considering to sort of, I guess, mitigate against the risk of this exposure to increased compensation and obviously more staff being able to bring claims, is being absolutely conscious of trying to resolve grievances and disciplinaries fairly, specifically with people who earn higher amounts, because obviously potentially they could receive more compensation at an employment tribunal. So that's ensuring that you fully deal with your disciplinary processes fairly and similarly impartially deal with grievances. And what we'd recommend is you do consider a resolution of those complaints at early stages to keep it internal where you can. Do use the resources available to you. So for instance, you've all got access to the dot-to-dot advice line, where we can give you guidance and advice about the steps that you're taking, just as a sounding board really sometimes for you. You might have a good idea about the steps that you're taking, but do contact us just to ensure that the steps you are already taking or thinking of taking are in line with what is best practice. What we do often find is that sometimes clients are contacting us at a later stage. They've gone through the investigation, sort of quite far into the disciplinary process, and sometimes it can be quite hard to unpick some damage to some extent that may have already been made. So what we'd recommend is, at the first sign of any issue or any concern, do pick up the phone to us, and certainly we can help you and guide and support you throughout that process. So do use the resources available to you, as it may help just sort of nip that in the bud internally. If it doesn't, and obviously it escalates externally, be mindful of the fact that claimants, your employees essentially, can't just raise a claim at an employment tribunal straight away. There is a compulsory step that they must follow, and that is to enter into a period of conciliation through ACAS. ACAS, many of you will know, aim to try and provide a resolution between the employee and the company. So having that sort of second stage where you can potentially stop that from going to an employment tribunal and obviously expose yourself to any risk and costs is a good option. And certainly what we're saying is that quite a lot of claims are being dealt with at an early conciliation stage. Do consider that. We often find clients come to us and say, well, as far as we're concerned, we don't think we should be paying this person a penny, and I completely understand that. But it's to step back from that, take objective advice from us as solicitors. We might say, you might have done everything bar one or two steps to the T, but even those one or two steps that you perhaps not followed absolutely spot on could expose you. So do always keep an open mind as to whether you can resolve it at that stage, because as the slide says here, otherwise it can then result in costly tribunal claims, which, as we talked about, with the increased compensation, as well as obviously legal costs on top. Other changes that are coming into place of next year, firing and rehiring is going to be prohibited. So this was the practice that some well-known companies actually in the press over the last few years have taken to, and that's to dismiss staff and then try and rehire them on less favourable terms. That's going to be prohibited, so that it'll no longer be possible to make reductions in pay, pension and benefits, nor to change hours or shift patterns or annual leave entitlement, those types of things, because it will be automatically unfair if you were to do that. That doesn't stop you making minor changes to contracts, but those more significant points, it will be prevented and result in claims. So can you change a person's contractual terms moving forward? Well, you certainly won't be able to do it unilaterally very easily without the employee's consent. It's only where, in a situation, the company's ability to continue as a going concern is at real danger, would an employment tribunal consider it's acceptable to make a restricted variation. So as you can see, really where the company's experiencing real financial difficulty to continue, would that be permissible? However, moving forward, therefore, it's key to ensure that you consult with staff if you're considering making changes, and really get their buy-in at an early stage if you're considering, for instance, making sort of reductions in pay to avoid redundancy, that type of thing, as an alternative to making redundancies. That sort of consultation with staff is going to be absolutely key. And then just some other changes beyond into 2027 and beyond. And as Stephen touched upon earlier, a lot of meat is to be put on the bones with these. We're expecting regulations as addendums really to sort of be put into place, but it's good for you to know about these things. So the first one is increased rights of pregnant staff and staff on maternity. The intention is that moving forward, when this legislation is introduced, it will be unlawful to dismiss a member of staff who is pregnant or on maternity. Now, what the guidance does say is that there still will be some restricted grounds, but what those restricted grounds are, we are yet to know. But to give you an example, for instance, if you've got a pregnant member of staff and that there is a clear safeguarding issue which becomes substantiated against them, there's a risk of harm to a child. Essentially, it's a gross misconduct offence. You would hope in that type of situation, the legislation will dictate that will form the view for restricted grounds for dismissal. So a lot's yet to be seen around that legislation, but the intention behind it is genuine and not to, to prevent scrupulous employers from dismissing pregnant staff and staff on maternity to make sure they're protected. But obviously, we need to see more around that to understand the grounds on which you can still potentially take action. There'll be changes to bereavement leave. Surprisingly, there's not sort of a statutory right to take bereavement leave if you need to take that time off when someone's passed away, a dependent. Under the legislation, people will be given the right to that unpaid leave for up to 1 week for a dependent, and that will extend pregnancy loss under 24 weeks, which is currently not protected. So those changes will be coming into place. Stephen's touched upon the sexual harassment regulations and the guidance on all reasonable steps, and we're expecting that the government will provide further clarity on that, so then we can see sort of in black and white what they're proposing insofar as the steps that you're required to take as employers. So hopefully we'll get some good guidance around that next year. And then protection for 0 hours contract workers. There's a lot of employers where they employ members of staff under 0 hours contracts and effectively still use them consistently to work a number of hours. So effectively that they are working essentially the same hours as a permanent worker. Under this legislation, the intention is that if somebody is working consistently and a number of hours over a set period, it will give that person the right to request that guaranteed work, those guaranteed hours moving forward. So it's designed to give more protection to 0 hours workers. And then finally, just in terms of the changes as well, changes to flexible work rights. You'll all be aware that a person has the right to request flexible work. You have the right to refuse flexible work as well, but moving forward, in addition to explaining the reason for refusal, you also have to justify why your refusal is reasonable as well. So that's just important for those of you who do get flexible work requests, being able to justify why you can't make that flexible work request. There'll be compensation for agency workers and 0 hours workers who often find that they have cancelled shifts or they're not being given reasonable notice of shifts. So if that is happening regularly, the legislation will provide that compensation will be given in those types of situations. And then just finally to touch on collective redundancies, which Adam touched upon earlier. Collective redundancies applies where you're considering making 20 or more redundancies. At this moment in time, that just applies where you're making 20 or more redundancies at one site. But in the future, under this legislation, if you've got different sites and you're considering making 20 or more redundancies across all of those sites, then you've got this duty to collectively consult about redundancies, which is a more rigid consultation process that you must follow. So that will be coming into place as well. Just very briefly to talk about us, we act for businesses defending tribunal claims and dealing with day-to-day HR and employment issues. And we've got a particular specialism in the early years sector, having supported a lot of nurseries for a number of years, and particularly obviously with our relationship with Dot to Dot and running the advice line. We do offer a HR retainer service. So for those of you who think that you might need assistance with looking at policies and procedures and obviously your contracts may need hands-on support and perhaps with HR matters and going through grievance processes and disciplinary processes. We do have our retainer service Workplace Plus in place, which is for a fixed cost. So if any of you are interested in any services, our details are on the slide, which I think will be distributed to you all after the event. And by all means, do contact us if you think that would be of use to you. So just in conclusion, there's obviously lots to consider and plan for here. We'd recommend you focus on the changes in 2026, first of all, because there are a lot of changes that Adam and Stephen touched upon, and then maybe to regroup later in the year to consider the changes I've touched upon, where there'll be further regulations to govern those, I'd imagine, later on in the year. It is important you do take legal advice about these things, and particularly to tighten up your contracts and your policies and procedures to include all of these things. So, as I say, if that sort of is of interest to anybody, by all means, do contact us. And finally, I appreciate we've gone over the hour, but we're happy to answer any questions that you might have just that have arisen in the group chat. I don't know if anybody has taken note of those.
Yeah, so if I can just come in there, Phil. So can I firstly just thank all of you, yourself, Stephen and Adam, for a really insightful discussion today about those changes in employment law. It's clear that we've got lots to think about as organisations, as nurseries within the field. So thank you for that, and thank you for your insight. Just as you said, really, Phil, you know, we have, if you're a client of Dot to Dot, then we do have access to the advice line. So please do use it. If you're unsure in any way at all, please contact your Dot to Dot account handler as well, if you're unsure how to access that. So we have got some questions. As we said, we will be sending the slides as well, and we will also send any further information that we have in terms of the Workplace Plus that Stephensons offer for you. So we do have a few questions that have come in. A quick question on sick pay. We are a childcare recruitment agency and we rarely book working for staff more than a week ahead. Is sick pay only payable if they are booked in for work, if on a contract of services? That's the first question, I think. Who wants to answer that one?
Yeah, I'm happy to take that one. Yeah. Part of the issue is whether or not they, well, what contract they're under and what rights are given under the contract. If they're an employee or a worker on an ongoing contract and therefore satisfy the SSP eligibility rules, and in those circumstances, it's not necessarily a case of looking at whether or not they're simply booked on a shift that week. However, with a lot of agency arrangements, there's often a distinction between periods when there's an ongoing contract between assignments, so there's still a contract in place, and then alternatively genuinely separate assignments where there's no overarching contract. But in practice, if a worker is engaged under an ongoing contract and they meet the earnings threshold, SSP can be payable even if the shifts are not booked that far in advance. Alternatively, if there's no assignment in place and no current contract that requires work to be offered or accepted, in those circumstances, you can see that SSP may not arise because there's no period of contractual work from which the absence occurs. Of course, with agency workers, SSP can be slightly complex. So it would depend on looking at what the contract says, and depending on who that contract of employment is with, they may well, if there are some enhanced rights, have entitlement to SSP. Alternatively, not if there's no assignment in place and no current contract that goes on and on, if you see what I mean.
Yeah, okay.
I don't know if that's helped, but it just helps to see the contract. But yeah, you can see the distinction between the two.
Yeah, no, that's great. And of course, as I say, the helpline is available as well for our clients. So we've got a couple of questions just to finish us off, really. A couple of questions on 0 hours. So we've got one about restrictions on 0 hours or low hours contracts. Thinking ahead, is it acceptable to offer permanent contracts with requirements such as we choose location and shift patterns? Can we still offer flexible contracts for those wanting a more flexible arrangement? Adam, is that you again?
Yeah, I'm happy to take that. I mean, broadly speaking, we can still offer permanent contracts that state a certain number of hours per week, that shifts will be rotated in accordance with business need. You know, staff required to work in certain geographical areas, and locations may vary between client settings. There's no issue necessarily with still having that flexibility. As Phil touched upon earlier, in particular, the right that's coming in is this right for them to have a certain amount of hours, or guaranteed hours, based on their actual working patterns. So we get to see the finer detail of that, but in the meantime, we're still able to offer contracts that reflect what those staff and the company agree between them, but just bearing in mind that as and when those rights arise and that legislation comes in, those are enhanced rights that they have that they can still request regardless necessarily of what has been in contract with them. But there is still that flexibility, and you can continue to offer that flexibility. The reforms are not intended to ban that flexibility. It's just to, as Phil outlined, stop employers requiring workers to be available indefinitely while providing little or no guaranteed work or income.
Okay, thank you. And I think just our final question then. So if a person on 0 hours not worked in the past 8 weeks due to work 3 days, subsequently calls in sick for one of those days, would they be entitled to a third of the lower of 123.25 or 80% of AWE over the past 8 weeks? As 8-week average happens to be 0, would that then be 0 sick pay owed? So that's a very technical question, isn't it? We've got.
Yeah, I mean, we could have a look at. Sorry, Steve, go on.
I was going to say it's fairly technical, but ultimately, if that reference period is applied, and they are not eligible, because they have to go through the various steps of eligibility. So the changes that Adam discussed was more about how the limit is being removed and more workers are being brought into statutory sick pay, and the waiting days, those 3 days, are going. But I think this is, if I'm reading the question correctly, and as you say, it is technical, the individual has not qualified as far as can follow for statutory sick pay. So it's a slightly different question in nature to what we discussed. But if I follow the question correctly, it doesn't appear that they will be eligible either under the old or the new regime, as far as I can tell.
Yeah.
Okay. But as we say, please do take advice on these things, because obviously it might need a fuller discussion. So please do take advice on this. So, okay. So I think all that is left to say, as I say, is thank you very much to the team. Thank you for your great insight. As I say, we will be sending the slides out to everybody. And please keep your eyes peeled for further webinars on topics that will be of interest to you. We try and give as much information as we possibly can to help you within your roles. And so, yeah, thank you very much. Thank you to all of our speakers. Thank you again.
Thank you.
Thanks.
Thanks, everyone.